Jacinda Ardern.
Thank you, Mr. Speaker. I want to make it absolutely clear that I'd say that there's probably no member in this House that would argue against the principle of ensuring that children are kept from harm. And I do mean harm in the broader sense of the word when it comes to criminal offending, harm perpetrated against the child themselves, exposure to the negative environment that is criminal offending, even if that harm is not directly to the child, or even the harm that comes from a child who has a parent who's engaged in criminal offending and loses them to the justice system and to incarceration. The question, therefore, is not whether or not we should be trying to prevent harm against children. It's how can we best ensure that we prevent that harm? How do we do it? And unfortunately, the bill that has been put forward by the previous member of New Zealand First, Asanati Lole-Taylor, just simply does not achieve that goal. We can see that if we go back to the general policy statement of the bill itself, which states, criminal offending by adults often exposes minors to serious harm. A primary example of such offending is the production of drugs, particularly methamphetamine. Minors are often innocent parties to criminal offending by adults and deserve protection from adults offending that puts them at risk of harm. This bill amends the Sentencing Act 2002 to make criminal offending in the presence of a minor an aggravating factor at sentencing. That is probably the most crucial part of that statement, at sentencing. This bill relies on an adult to first be charged, successfully prosecuted, and then sentenced for the crime of producing methamphetamine. It does not make the act of producing methamphetamine in front of a child, in the presence of a child, endangering a child, an offence in of itself. And that is probably one of the most significant issues with this bill. And there's a couple of examples that I want to give as to why that means that this bill will not succeed in the way that the member perhaps intends. We actually already know, first of all though, Mr. Speaker, that the Sentencing Act does allow aggravating factors to be taken into account, and we heard submissions which suggested that actually the intention that the member included in this bill was already achieved by the existing law. The Sentencing Act 2002, as introduced by Phil Goff, allowed flexibility around aggravating factors. Instead, perhaps I think the original drafter of this bill intended for something quite different to be occurring. We do know, for instance, that children are currently being exposed to the manufacturing of methamphetamine, and we know that because of the research of one woman. I want to pay tribute to Chloe Barker. She's an Auckland-based lawyer who a few years ago now analysed environmental science research data related to children and clandestine labs as part of her master's degree. She worked very closely with the police. The police were very cooperative in the work that she did. And she found that from 2006 to 2010, there were 191 children living in the presence of methamphetamine labs. Now, those were the ones that the police successfully broke into and closed down and subsequently laid charges against the offending adults. We know that that has been a steadily increasing rate, though. In fact, in 2002, 34% of all labs discovered by police had children present living in the confines of the lab itself. We know that from a more detailed audit in 2008 and 9 that in 21% of labs there was evidence that the children were present during the manufacturing process. That in 45 of 53 labs that reviewed there were evidence of chemicals within reach of children, and that in 36 of 53 labs chemicals were stored in food or drink containers, and in one case in a child's school drink bottle, complete with their name, their school room number on the bottle itself. We know that that also has an effect. Now, there hasn't been quite enough research in this area, but we know that from hair follicle samples in 23 of 26 children tested, methamphetamine was found to be present in those children's hair follicles. We don't, however, know the long-term effects of that presence, but anyone, I assume, would agree that that clearly indicates harm in some form or another. But here's the kicker. Despite all of that research and that evidence, there is a low rate of successful prosecution connecting the child to that criminal offending. Now, as Chloe herself is quoted to say in the Police Association magazine, quote, currently in New Zealand, general child abuse laws are used to prosecute those who have exposed children to the dangers of the methamphetamine manufacture environment. So they're being prosecuted under child abuse laws. She goes on to say the Crown has needed, though, to show that this exposure was willful and likely to cause unnecessary suffering, actual bodily harm, injury to health, a mental disability or disorder. Attentive evidential questioning and interviewing of the suspect and witnesses is required to establish intent. Now, as you can see, if you're prosecuting under general child abuse laws with that threshold test...
Sorry to interrupt the honourable member. The time has come for me to leave the chair for the dinner break. This debate is interrupted and I shall resume the chair at 7:30.